Excellent. Thank you, Senator Tillis. And Mr. Chairman, thank you for the hearing today. It's so appropriate that we have this. I'm from Tennessee. We have thousands of artists and songwriters and musicians, and we have actors and actresses, we have authors and publishers, and everywhere I go, people are talking about the impact of AI to the positive or the negative. You know, you look at healthcare, you look at logistics, you look at autos, you look at entertainment, and there are pros and cons. But the one point of agreement is you got to do something about this so that it is going to be fair and it's going to be level. Mr. Harleston, I want to come to you right off the bat because you mentioned the NIL issue, which I think is an imperative for artists to be able to own that. And you also mentioned the right of publicity laws. And of course, those are state level laws. And as you rightly said, we don't have a federally preemptive right to publicity law. And I think the dust up, a lot of people came to realize this over Drake and the Weekend and Heart on the Sleeve. And this is something that does have to be addressed. So for the record, give us about 30 seconds, and then you guys see your capable team behind you. You can submit something longer in writing if you'd like on the reason state-level publicity laws are not enough.
In 30 seconds. State level right of publicity laws are inconsistent from state to state. A federal right of publicity that really elevates right of publicity to an intellectual property is critically important to protect.
Okay, I'm going to help you out with this. A federally preemptive right to publicity law would provide more of that constitutional guarantee to her works that Ms. Ortiz has mentioned.
Absolutely.
So, all right, and
we will follow up with you, Senator.
Yeah, excellent. I think something in writing would be very helpful there. Now, I think it was very appropriate that you had Spotify and Apple Music take down Heart on My Sleeve. Important to do. And talk about the role that the streaming platforms should play. Should they be the arbiter when it comes to dealing with this generative AI content?
The streaming platforms, we acknowledge that they're in a challenging position, but certainly in some instances when it's clear that the content that's been submitted to them for distribution.
So a knowing and willingness standard would be nice.
That would be very nice, yes.
Okay, I'm helping you out there.
You're doing
Thanks
great.
for being here. Okay, Professor Sag, want to come to you. This spring, the Supreme Court issued what I thought was a very appropriate decision in Warhol versus Goldsmith. And I was very pleased to see them come down on the side of artists. I filed an amicus brief in this case arguing for strong fair use protections for creators. Now, we've been through this thing in the music industry where fair use became a fairly useful way to steal my property. And artists don't want to go through that again. Right, Ms. Ortiz? It didn't work the way it was supposed to. And I would like for you to talk for a moment. Should AI, unlicensed AI, ingestion of copyrighted works be considered fair use when the output of AI replaces or competes with the human-generated work? Now, Ms. Ortiz has laid this out fairly well in her comments, and the Supreme Court has sided with the artist in Warhol versus Goldsmith. But this fair use standard comes into play every time we talk about our fabulous creative community and keeping them compensated. So the floor is yours.
Senator Blackburn, commercial replacement should not be the test. The test should be exactly what the Supreme Court said in the Andy Warhol case. The question is this significantly transformative? What that means in relation to training AI models is, does the output of the model bear too much resemblance to the inputs? Now, that's a different question to, is it competing with the inputs? Could it be used as a commercial substitute? If you look at some of the old cases on reverse engineering software, companies were allowed to crack open software, find the secret keys to interoperability, and build new competing products that did not contain any copyrightable expression, and the court said that that was fair use. So I think on current law, the answer is no. Potential substitution in terms of a competing product is not the test. The test is, are you taking an inappropriate amount of an artist's original expression?
Well, my time has expired. Thank you for that. We just don't want it to become a fairly useful way to steal an artist's product. Thank you, Mr. Chairman.